everyone. We're here to have a meeting of the House Judiciary Committee. I see Judge Guy and Judge Lawton Stevens. Glad to have both of you here. You learned the ropes from Judge Stevens? He's a good one. Still got my synopsis of the story of the Western Circuit. Sitting on my desk in there. Always made the Western Circuit, which is east of Atlanta. You know, never quite figured that one out. Well, glad to have you here today. We have 4 bills. We removed one bill which dealt with the abandoned motorhomes. I've got some things I'm looking at on there as far as potential changes. So if you hear about that bill, it's been taken off the calendar for the day and be probably back on for Thursday. I know we have Ms. Price here. You've got to get to another committee, you said earlier, or later, now. Why don't I bring you up, if you would come on up here and have a seat and tell us about your bill. And this is going to be House Bill 668 LC 41 1261 is the bill number. And you can go right ahead.
Thank you, Mr. Chairman. House Bill 668, as you said, LC 41 1261, has passed a subcommittee earlier and moved on to your committee, and I appreciate that very much. This bill seeks to modify slightly Code Section 29410 relating to petition for appointment of guardian and requirements for petition, and basically it allows a petitioner to petition when the proposed ward is 17 years of age instead of at the time that they turn 18, and it can have that time frame to petition, get their supporting documents, and then at the time that they reach 18, it would take effect if the judge so ordered. And this is to prevent a gap in which after the age of 18 that proposed ward may fall into untoward activity or be taken advantage of. So it's a great opportunity to prevent problems and to provide continuity. At the subcommittee hearing, we did have the mother of Darby, who was the proposed name for this law, Darby, and the mom explained that she knew in her circles of friends who gathered to talk about the issues that they had with their children who had various degrees of either developmental disability or other issues whereby they would not be expected at the age of 18 to be independent, that she knew that sometimes there were issues with people just waiting for them to turn 18, and then there would be nothing the parents could do about it should they do something to them. So that's kind of it in a nutshell, and I'm happy to try to answer any questions.
Yes, let me add to what I understand is the purpose of the bill is where you have a child who already carries some disability.
Correct.
And is not competent, capable of providing and taking care of themselves. This will allow a petition to be done before 18, so you lose this gap time that you have to now wait for until they're 18 and then file to seek a guardian or a continuation, in this case, of the guardian.
Correct. And it would not take effect until they turned 18, but at least everything be ready to go.
Do we have anybody here from a probate court? Wheat Lake, that's right. Ms. Oliver, let me ask you a question. Just came to mind, we have, of course, difference between guardianship and conservators.
Yes, sir.
Is this going to take care of the issue of a conservator that for a minor child?
Well, as you know, the probate council very smartly required that lawyers use forms, and the form has a checklist for guardianship and conservatorship. And when I'm working with parents on that, we make an individual decision: is the child going to have any money?
If they did have any, yeah.
Yeah. And so it's not a separate proceeding. It can be very easily addressed within individual families. Most of these children are SSI recipients, Medicaid recipients upon turning age 18.
Mm-hmm.
Most of them are not going to have, as Ms. Stevenson knows, assets of any kind. If the family's in a position to do the kind of planning which your bill.
Why don't you pull your mic over so we can get you to hear? I think I got you on number 16, is that it?
See the number, but,
It's on now, yes, sir.
Try that one, that's it.
So I think that the way the probate courts work in terms of forms and having a check for guardian and conservator will be very
Okay.
helpful in this instance. And I think the bill is a good idea because I see families who are planning ahead and who do not want a gap
Mhm.
between 17 and 18 and
Yeah.
don't want to have that necessary delay.
So back to the question though is, will this cover the ability to have that continuation for conservator, or do we need to do something to address that type issue by another bill?
Let's see if the
So it talks about just being for guardianship. The reason the proposed ward not 18 years of age, an order appointing a guardian shall take effect upon the proposed ward attaining 18. And
Well, it says provided will satisfy the prerequisite findings in A, and I don't think, I may not be seeing the right language you're talking about, but I don't think that a capacity issue is different for guardianship or conservatorship. So if you have the right to file a petition on capacity issues, which I think is what A talks about, then it could cover either the guardian or the conservatorship. I'm happy
Okay.
to be corrected on that if you disagree with
we
me.
just curious, Judge Caldwell.
Mr. Chairman, just having done a couple of these within the last couple of months, as a general practice, I'm sure you know, probate judges just combine all of this together. Now, I'm not saying are they supposed to, but they do. If you apply for a guardianship, they're going to ask you at the same time about a conservatorship at the same time.
Okay.
It may be necessary, it may not be necessary, but I've never had one that did not do it all together at the same time.
We'll leave it till somebody brings it up as a problem. I don't want to be the one to bring it up.
I don't anticipate it be a problem
Yeah.
in my county,
For these parents that are doing good planning for the SSI recipient, a conservatorship would not be necessary, but I don't think I would address it if it were me in this bill.
It's a good bill. We all like the purpose up behind it. So is there anyone else who would like to address the committee on House Bill 668? If you're not here, we'll close off further public comment. The bill is now in the breast of the committee. Do we have any discussion on the bill? There being no further discussion, the chair will entertain a motion. Motion is due pass. Do we have a second? There's been a second to it. Is any discussion on the motion? Any offer for amendments? If there being none, the chair will call the main question, which is due pass. House Bill 668. All in favor signify by saying aye. Opposed, like sign. Motion carries. Thank you.
Thank you, Mr. Chairman.
Dr.
Thank you,
Price.
committee.
Mr. Illustration, we'll bring you up for your bill. You got another meeting to go to. And this will be House Bill 121, which we have from last year, and it came back to us. Nice big thick bill.
Well, thank you, Mr. Chairman. I'm operating off of LC 297761 ERS. Mr. Chairman, just to begin, this legislation was brought from the State Bar Fiduciary section, and
Hold 1 second, because I'm looking at the bill. I got a different.
I apologize, Mr. Chairman.
Okay, 7761 is what you have on here, but the bill I've got in my file here is 7796 ERS. Is that a mistake?
No, sir. Your bill number is correct.
The bill number is correct.
Yes, sir.
Okay. Which one is the current one?
The one that
This
you
one
have,
got, okay.
Mr. Chairman.
Thank you. Okay.
This
Now-
was reported favorably as amended, committee substitute as amended at subcommittee. And I want to thank Chairman Fleming for an in-depth look at the subcommittee hearing. The bill has been reviewed by the fiduciary section, and the State Bar Fiduciary section supports it. It's been reviewed by Professor Mary Radford, and
Put that stamp of approval on it.
yes, sir, it does. And so if it would be all right, Mr. Chairman, I'll just briefly do a walkthrough.
All right.
House Bill 122 was concerning the rule against perpetuities. That has been added to this bill in sections 1 to 3, making Georgia consistent with other states that has a higher number of years and rules in the rule against perpetuities. As to Section 4, it provides a statutory mechanism for one party to receive notice and gives consent on behalf of another party in matters relating to trust. It also provides that a court may appoint a representative, such as a guardian, for any party whose interest is unrepresented or inadequately represented. That is really what the rest of the bill hinges on. Section 5 provides a statutory mechanism for non-judicial settlement agreements. These are practically happening all the time and maybe not seeing a courtroom, but this would codify the ability for the parties, all parties involved, to reach a settlement agreement. Section 6 provides that a transfer of property naming a trust as a grantee is deemed to be a transfer of property to the trustee of that trust. Section 7 provides basic statutory mechanisms for modifying irrevocable trusts. This is a common trend that we're seeing in other states. It would allow for 1, court-approved modifications with the consent of the settlor and all beneficiaries. 2, court-appointed modification after death of the settlor with the consent of all beneficiaries. And 3, discretionary modifications by the court to facilitate efficient administration of the trust. Section 8 is new, Mr. Chairman. This was not included in House Bill 121 last year, but it would provide a statutory mechanism for the distribution by a trustee of trust property from an existing trust to a new or amended trust. And this is what we commonly refer to as decanting. And I just think of it this way. You have one existing trust out there. It would allow for the property at issue to be distributed to multiple trusts if that's what the parties choose to do. It's actually going on right now, and there just isn't a statutory backdrop for it. We would provide that here. Sections 9 and 10 remove code sections that have been covered by Section 7 of the bill. Section 11 increases from $50,000 to $100,000 as the maximum size that a trust can be terminated on the basis of being insufficient to justify the cost of administration. Effectively, what we're talking, and it's my understanding that the $50,000 number was created in 1991, and the danger that you run into is the necessity of having the trust. Means that the administrator just eats up the property that's in the trust if it's a very low dollar amount.
So you have it come to a termination. What happens to the distribution if you have an open-ended question about future-born heirs?
If I could turn to Mr. Jurich,
Well,
who
come
is
on.
the former president of the fiduciary section, he can give you
This is
a concise answer.
Good afternoon, Mr. Chairman.
identify us, if you would.
My name is Nick Jurich. I'm the current former chair of the fiduciary law section, but current chair of our legislation committee and our trust code revision committee. So it was our committee that worked on the HB 121 last year and this year
Yes.
as well. Thanks for having us before your committee today.
Tell me about that.
To answer your question, I don't have the exact code section before me now, other than the section that sets the dollar amount. But the trustee would be directed to distribute the property to the current beneficiaries of the trust, who would be entitled to the income or principal of the trust, consistent with the way the trust provides for distributions. There's actually in the code an explanation of how it is supposed to do that. And if it is unclear exactly how the trust would be distributed, then it may not be possible to terminate it under this easy provision, and it may be
So if you have
you'd
a
have to go
flat,
to
you have
court.
potential unknown heirs because of the ability of the heir to be born
Right.
that is not yet in life and
Right.
could come about.
Then you may
Can-
have to wait
Okay.
or have to go to a court to ask for a direction on how
The
to
next
terminate
one, so
it.
you could have the heirs all get together and consent of the trustee enter into an agreement to terminate it, like we have
Definitely.
earlier.
And that's now facilitated by the non-judicial settlement agreement
That's-
provision
that's
that we
where
have
we'll-
earlier as well.
okay.
Yes, termination and modification are now both covered by that same provision
Okay.
with non-judicial settlements.
Thank you. Go ahead, I'm sorry.
Mr. Chairman, sections 14, 15, 16, 18, 19, 22, and 24 remove or change provisions that have been covered by section 4 of the bill. And just to finally summarize, trusts right now are being drafted in other states. Georgians are traveling to other states to have their trust drafted because state law is more favorable to allow for the trust to meet what the client wants. And this bill is for the purpose of addressing that and fixing that along those lines. Would ask for your favorable consideration. Be happy to answer any questions.
Questions from any member of the committee, the presenter? Let me go back with you on section 8. Give me some in-depth, or clarification, a better word, to what we're doing here on section 8 with the
Decanting.
Mr. Chairman, if I may, I'm being called to another
Sure.
committee. Would it be all right if Mr.
You go ahead
Jurich
and be
served in my
excused.
place? Thank you.
yes.
Section 8, it goes by different names, distribution in further trust or decanting. What it does is this provides a statutory mechanism for what is thought to be a common law principle, which is that if a trustee has the power to distribute trust property in its discretion to a beneficiary, that power to distribute to the beneficiary includes the power to distribute it not only outright to the beneficiary, but in trust for the beneficiary. It's an idea of the sort of greater power
you got minor
includes the lesser
beneficiary?
power, including a minor
So you
beneficiary.
have a direction of distribution for a beneficiary who at the time is a minor, or we're saying that the trustee could then set up a trust as opposed to just continue holding it?
Correct. And since there's a Georgia case from the 40s, and there's cases in other jurisdictions as well that establish that the trustee can do that. And that means that the trustee can take the opportunity, possibly, to what is essentially modify the existing trust by creating a new trust that might better reflect the needs of that beneficiary today. For example, common is when there is possibly a need to take into account special needs of that minor beneficiary that may not have been anticipated years ago when the trust was put into place. So trustees are doing this now in Georgia under the common law, but there are a number of states that have codified this idea of decanting or distributing in further trust and provide a framework for doing it in the statute to give trustees more comfort in doing that. And this would give it to us. There's a Uniform Act that's just recently been developed called the Uniform Trust Decanting Act. We use that as a guide for the provisions to put in this section, but we didn't follow it exactly. It was a very long statute, and we thought this worked.
So again, any questions of the presenter by the committee? If not, we'll appreciate your comments. Anyone else wish to address the committee on House Bill 121? If not, we'll close off further public comment, and the bill is now in the breast of the committee and a discussion among committee members regarding the bill. There being no further discussion, the chair will entertain motion.
Do pass.
Motion do pass. And seconded. Any offer of amendments? There being none, the chair will call the main question, which is do pass recommendation, House Bill 121. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Thank you. Next we have is Ms. Beskin. You're here on your bill, which is House Bill 654. Would you like to present from there, or you want to come around in front?
I'll present.
All right, push. 654. And,
Thank you, Mr. Chairman. Can you hear me?
yes.
I'm here today with House Bill 654, which would implement the recommendations of the Georgia Child Support Commission. I have here today Ms. Pat Bogadono, who is an attorney on staff with the Child Support Commission, if you'd like to come up here and make your comments. We also have, I see Judge Lawton Stevens from Athens, Clark County, who spoke to this bill yesterday. Would you like to speak, Judge Stevens? Any other judges who may be here who have an opinion on it? But simply, this bill does what we attempted to do last year, but actually kind of did the opposite of it. And this bill provides that it is discretionary but not mandatory, and we got Judge or Guy. Thank you. Or Guy, right?
That's it. From Brunswick.
It is discretionary but not mandatory on the part of the judge to require multiple child support worksheets if it's anticipated that there may be a change of child support obligations within the next 2 years. And with that, I will let the presenters make their comments.
If you would, identify yourself and tell us about the bill.
Be happy to. Thank you, Mr. Chairman. My name is Pat Bonadono. I'm the staff attorney for the Georgia Commission on Child Support. And the commission wants to pass this bill because we have gotten so much negative feedback from the way it was passed last year, which made it mandatory for everyone to file multiple worksheets in cases in which child support was being determined for more than one child. And so this makes it discretionary. It's optional. The parties can choose to or not. And it limits it to 2 years because the commission believes that's the foreseeable future as to when a child's actually going to graduate and or be 18, you know, and be done with high school, which is what the requirements are in order to stop paying child support. So if there's going to be a step down in child support within the next 2 years, then the parties can decide to file separate worksheets for the remaining children in the home so that the amount being paid will not stay at the higher level with more children.
Okay. And Judge Stevens, I guess this will aid the courts,
Yes, sir.
let you get home early.
Yes, sir. Get home before 9 o'clock some night, maybe. But the council fully supports the legislation. I think it'll make it better for the litigants and be more efficient.
All right, Judge Guy, you want to comment?
I agree. I think it will give discretion back to the court about whether we need to have these extra worksheets instead of creating them when we don't need them.
Gotcha. Okay. Appreciate your comments. Anyone else wish to address the committee on House Bill 654? If not, we'll close off further public comment. The bill is now in the breast of the committee. Do we have any discussion by committee members regarding the bill? There being no further discussion, the chair will entertain motions.
Do pass.
We have a motion do pass. It's been seconded. Any discussion on the motion? Any amendments? If none, chair will call the main question. Was recommendation do pass on House Bill 654? All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries.
Thank you, Mr. Chairman.
Thank you. Glad to have you all with us.
Thank you.
I think our last but not least bill is Ms. Oliver's bill, 738. You're on, and you ready? There.
Thank you, Mr. Chairman.
Yes, ma'am.
House Bill 738 provides the standing, the authority of interested person to propound a will. Under existing law, and particularly a case that was decided in 2014, the Supreme Court of Georgia ruled, in essence, that a creditor of an estate who was not the named executor and who was not a beneficiary or legatee of the estate did not have standing to offer a will for probate. This 738 corrects that decision and defines an interested person who has the authority, the standing, to offer a will for probate to include creditors and the other list of individuals that is set forth in 13 to 17. I've included a copy in your folder for those of you that want to spend a lot of time talking about the Ray and Stevens family disputes and the facts that gave rise to this case. But in essence, Grady Stevens died quickly within a month of pancreatic cancer, and he, during that period of time, signed a will and deeds benefiting his daughter as the named executor and the total beneficiary. His named daughter did not probate that will. She did not feel that her father had the capacity to sign that will and chose to believe instead that he did not have a will and that he chose his estate to go equally to she and her brother. The deceased brother, who was a creditor of the estate, who was owed money by his deceased brother, tried to propound the will so he could have standing in court to be paid the money he was owed by his brother. And the Supreme Court of Georgia decided that the brother, who was not the named executor, not a beneficiary, was not an heir, of the deceased did not have standing. I think that's a policy issue for us
Yep.
to decide, and I suggest, and this matter was brought to Chairman Willard's attention by Mary Radford as a possible gap, and the probate council has reviewed 738 and has no opposition, believes that it might be an appropriate policy change for us to consider. We thought about adding it to the probate council bill that has been hung up based on an issue of vacancy, but decided this was a cleaner way to do it, because it is a pure policy question.
Good point. It might be, to add to your comments on this, the definition of interested persons who have the opportunity to offer a will for probate has been set up through case law coming down from common law, and is really not something we ever had in our statute per se. So what we're doing here is an initial attempt by the legislature to define who are to be considered those persons who have the opportunity as interested parties to offer a will for probate if the named executor doesn't do so. So that's kind of where we're,
The pivotal case
Driving.
was Finch versus Finch in 1853.
look at here.
Good year.
I remember that case.
And the Ravy Stevens case seems to inappropriately, in my view, narrow the opportunity
Yeah.
for.
Yeah. So we're just putting now with a statutory stamp, the full classification of parties who would have that opportunity as being interested parties. Anyone want to speak further on House Bill 738? If not, we will close off further comment. The bill is now in the breast of the committee. Do we have any comments or discussion by the committee members? There being none, the chair will call for call for a motion on the bill. Motion is due pass. Is there- and it's been seconded. Any discussion on the motion? No discussion, no further amendments. The chair will call the main question, which is due pass recommendation of House Bill 738. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. That is all we have for today, except we do want to remind committee members that the State Bar, and I think our representatives left, there was going to be a dinner for the committee by the State Bar, I believe on February 15th.
What I was told.
Good. Glad you remember. February 15th. So put that on your calendar at Piedmont. Piedmont
That's what I was told.
Country Club, yeah. Okay.
You need to tell them to change that. That's Thursday night, and us folks don't live in Atlanta. We're going home.
All right. Okay, good point. Might be something we need to consider. We'll for that, we'll consider the meeting adjourned. Thank you, everyone.